The topic for today's discussion, it's litigation funding in the insolvency and bankruptcy regime, and it's a very interesting topic. Not only because insolvency is a very hot topic in India, given that it's the first regime in India where a formal debt resolution platform is made available with the good statutory force over it. We have seen some of the largest cases getting resolved with the change in the management, which were never expected. SR Steel, Bhushan Steel, these are very marquee cases. Insolvency law, and the whole ministry dealing with insolvency law boast of these marquee cases. Litigation funding globally, it's a phenomena that now it's a very matured concept, and has also been looked very actively in the matured jurisdictions. In India, litigation funding is still at a very nascent stage, and of course, Piyush, I'm sure that Piyush would be raring to go to share his experience on this. But in India, we're still learning, how litigation funding can help arrive at a better resolution, better recovery for the lenders. I would say that litigation funding should also be discussed on this panel in the context of an asset class. If you know how litigation, also called actionable claims, can be used as an asset class to sort of improve the recoverability in the insolvency regime, because litigation funding per se, it's a concept where outside funding, or the funding agency or the investor would provide the financial support for litigation, which in an insolvency process scenario is something which is a subject matter of a resolution, because ordinarily resolution professional would be more focusing on the completion of the process and bringing a new RA in. I think this is something perhaps which is of more importance in the context of a resolution post approval of the NCLT, where an investor can come in and provide some support for recovery through pursuing the litigation cases. Now we have a distinguished panel here. We have a practitioner who has seen enough of the litigation funding abroad. We also have two investors to give the investors' perspective here. So I will start with Piyush. Piyush, that in India it's a very, very new concept. So why don't you share with us your experience of how it has developed in other jurisdictions, and how we can sort of extrapolate the rules and processes in the Indian context. Over to you, Piyush.
Sure. Thank you, Anoop. I will start with sharing how Singapore has looked at this. And I mean, as a common law jurisdiction, that's something common between India and Singapore, is that both are common law jurisdictions. So traditionally, the concepts of maintenance, Jeopardy existed in Singapore as like in India, and which were concepts that we borrowed from England. But what has happened in Singapore is, in the last, I would say, more than 6 years, because it was first the case laws which changed the understanding, and subsequently was followed up by change in the legislation itself, and which has, continues to be more refined. In fact, there were changes as early as last June, just a few months ago. So of course, as a problem, because companies in liquidation, insolvency are in need of funding, because the reason why they are in insolvency is because of some reasons why probably there was things which were not managed properly, and they don't have the funds to really carry on their business, and they need to be restructured. So that's something that has been recognized in Singapore as a problem, that look, yes, there is maintenance in Jeopardy which exists, But at the same time, you need to realize that these companies need the help to revive itself, or even for the creditors to realize the fruits of good claims which the company may still have, even though it is under liquidation. So going back to 2015, where in a case in Singapore, that's what happened was that the company had actionable claims which it had commenced before going into liquidation. And of course, the liquidators did not have the money or the fund to fund that litigation. So there was something called an assignment agreement which they came up with, where the shareholders, which and one of them also happened to be a creditor of the company, they said that okay, these rights, these actions, can be assigned to us. We will fund the litigation, and whatever money comes can first go. I mean, there was a waterfall mechanism that they talked about. Will first go to the company, then will come to the funders, so to say. So there, the question of maintaining champerty arose, but the court took a pragmatic approach to all this that said, like, no, here it's something that the Companies Act in Singapore recognizes, that the liquidators have the right to sell these actions in things that the company has. And more importantly, what's important is that if there will be no funding, the company will have nothing. So that's something that the courts have realized, and there have been other cases after that as well. But more importantly, in 2017, the Singapore amended the Civil Law Act to actually do away with any liability in respect of the tort of maintenance and champerty. And that was a watershed moment because that clarified the law. Because I'm not very sure in India how clear the law is on this, because there is always a cloud of doubt whether this can be done, how can it be done. But in 2017, when they changed the law in Singapore to expressly do away with the tort of maintenance and champerty, is what paved the way for third-party litigation funding in Singapore. At that time, it was limited to only international arbitration, and I'm sure Arvind will speak more in detail about this, in his part. But that paved the way. It clarified a lot of things, and then recently in June, the government has also further clarified and expanded the ambit of third-party funding in Singapore to include even domestic arbitrations. So that's where the legal regime comes, where it realizes that, look, this is the need of the moment, especially now that COVID has put further strain, on companies. And this could be an avenue where meritorious claims can be pursued by companies, even though they may be in liquidation. So that's something that has happened, and that has happened because of the legislative changes that have happened in Singapore, led first by the courts, where they have given judgments which recognizes and does away with champerty and maintenance. And then secondly, of course, reinforced by the legislative changes in Singapore, where it is expressly recognized that there is no liability for any tort of maintenance and champerty, explicitly clarifying that it is applicable to international arbitration and now even to domestic arbitrations.
Thanks, Piyush. Thanks for sharing this. I think it's important to know what the other countries are doing, and we definitely need to take a clue from there. For the uninitiated, just to explain what is champerty. Champerty basically, it's a common law, concept where any arrangement which motivates the litigation, or which is linked to the payment basis, the success of the litigation is not encouraged, and that's in a very, very sort of raw what champerty is. The same common law principle was introduced in India as well, and the current law is under Section 6E of the Transfer of Property Act. So we have the concept of actionable claim. Actionable claims can be transferred, can be assigned, but there is an exception to that under Section 6E, which says that mere right to sue cannot be transferred. What it means is that, if let us say you have a litigation where you can claim damages from the other party under the contract, that if you want to assign, that is something which is not assignable in India as at the moment. And it is also, as I said, that it's a concept taken from the common law. But what I also understand is that there are adequate enough judgments even in the common law jurisdiction, where in a liquidation scenario these kind of transfers are allowed. Now, we also have our liquidation rules. Our board, insolvency board, is very, very active. Insolvency board has recognized this recently. They have introduced regulation where they do say that if there are, any underlying assets in these litigations, that can be transferred. Now, it's yet to be seen that how it is interpreted. I think it's a very, very important and a significant asset class, especially in some of the sectors like EPC or and also any other infra project where there are interactions with the regulators like NHAI or DGH. The ability to generate revenue from these asset class, from these arbitrations and other litigations, is massive. And therefore, I think India also need to look at the law which is getting developed now in Singapore and see how we can use that experience. Now, Arvindran, I mean, you've been from an investor perspective, what do you think that what an investor would like to see before they can think of investing in this kind of an asset class in India?
Thanks for the question, Anoop. I'll just make a quick comment on the discussion about the assignment of claims, if I may. So the issue around the doctrine of maintenance and champity obviously differs from jurisdiction to jurisdiction, and as you correctly point out, it's the assignment of the claim itself that is prohibited in some jurisdictions. And it's interesting to know that that's actually enshrined in at least one piece of legislation in India. How we go about getting around the restriction is that we take an assignment not of the right to sue or the claim per se, but really an assignment of the right to recover over the proceeds. So in other words, for all practical purposes, the company in question to whom or to which we are extending funding remains the claimant. And so the assignment is over the proceeds from the action. And so that common law doctrine isn't engaged. So I thought maybe it would be useful to clarify for members of the audience how a disputes funder who, like ourselves, have a workaround for this issue. Now, naturally, in India, there is a certain litigious culture, and it is open to a respondent to challenge the validity of the funding agreement on maintenance and champity grounds. But I understand by way of speaking to a number of Indian lawyers that the landscape has changed. The number of judgments that actually view this sort of funding as being permissible. And again, as you correctly pointed out, the insolvency world has for a long time recognized that this sort of funding is permissible in that context. So I just thought to quickly comment on that issue. And before I answer your question, I hope you don't mind if I just take a minute to introduce who we are. I'm an investment manager with Omni Bridgeway. We're the largest third-party funder or disputes funder, litigation funder. There are a number of terms that I use to describe us in different parts of the world. We're the largest in the world by team size. We've got about 150 specialists deployed over Europe, Singapore, and Asia. And with about $1.5 billion in funds under management. And really our business is in assessing these sort of claims that companies may have, awards that companies may have after engaging in a dispute resolution process, trying to ascribe a value to it, and then providing financial solutions to these companies on a non-recourse basis. And that's really a key feature of what disputes finance entails. Non-recourse simply means that unlike a traditional financial institution from whom you might borrow, there is no right of recourse against the borrower. And I use that loosely because we don't look at our clients as borrowers, because it's not really a loan or lending kind of relationship per se. And I'm happy to explain some of the finer points, but I'll leave it at that for a moment. Your question was, what is it that we look at as funders? There are really three metrics. The first is, in assessing a claim, we look at merits. So is it a good claim? Will it succeed? And that's done in a collaborative fashion with the legal team that has conducted the matter. We oftentimes get a legal opinion from them, and then we form an in-house view because we are comprised of former lawyers like myself who have had fairly extensive experience in arbitrations and litigation. The second criteria we look at is quite an important one, particularly in the Indian context, and that is the prospects of recovery. So if you have a respondent against whom recovery is going to be difficult, then that is something that we will take into consideration when deciding whether or not to fund a matter. And maybe I'll quickly just comment on that in the Indian context. Now, when you talk about enforcement of an award in the Indian context, there is a peculiarity in the Indian jurisdiction, and that is, we see that very often emerge when we consider awards that have been rendered against PSUs. So very often the opportunities that we see are from Indian contractors or companies in the infrastructure space. And so it is almost par for the course that these PSUs engage in the court process by filing Section 34 challenges and so on in order to try and overturn the award. So specific to the Indian context, what we will consider as part of the risk analysis is timing. How long is that process going to take if the Indian court process is engaged? And obviously, it's encouraging to see that India today is different from India 10, 15 years ago, where it's more pro-arbitration, where the courts are more prepared to uphold awards. Of course, there's some subtle distinctions between international and domestic awards, and I don't want to get into that. That's really Piyush's domain. But that's one thing that we would bear in mind. And so how easy is it to recover from a respondent or counterparty? And one thing that Omni Bridgeway does very well, and in fact we're leaders in this, is that enforcement capability. So if you have a counterparty or a respondent with assets outside of, say, India, what we can do, leaning on our 35 years of experience, is to develop this multi-jurisdictional enforcement strategy and then work out with you the sequencing, timing, where you go, where are the assets, and then map that all out for a potential client. The third criteria that we look at is the economics of the deal. So we work on what is known as a roughly 1 to 10 ratio. So if a claim is, say, worth $10 million US, then the amount of funding that we can extend is $1 million. So that's really a snapshot of some of the things, or really the three main things that we look for. There are a number of other things that we also consider as part of our due diligence, but perhaps I'll stop there. Not I'll take up too much time.
Thanks, Arvindran. I think it's very important, information that you shared, and I do agree with you. The distinction that you made between the assignment of the underlying asset versus the assignment of mere right to sue. And you're right that now there are a good number of judgments in India as well, where the the assignment of the asset have been held valid, even if it includes an incidental right to sue or to follow up. I mean, that's, I think, very typical of a debt assignment agreement, because debt invariably will have DRT cases. The only, I think, the problem area arises, is where you file the claims basis damages, your estimation of the damages, your estimation of the liquidated damages, while it may be very clearly laid out under the contract, but since it's not crystallized, therefore it falls in that crack that how do you treat them, and the jurisprudence is not developed yet. But I believe that the way it is understood in the other common law jurisdiction, that in case of a liquidation, the rules of champerty must be ignored. In some of the cases, at least, that I've seen, because if you do not do that, then the company gets dissolved, and you actually do not have the entity to pursue these cases. So therefore, I think there, some rules need to be developed on that ground. Now, also, I think on the other part of the investment that you just mentioned, I think it's very important for the lenders in India to appreciate this as an important asset class. See, so far lenders have not given too much significance to this. It is only recently that this has been really considered seriously, and till date, I think the level of diligence is not very deep. The way you explained how the claims have to be analyzed and the value needs to be arrived at, I think in Indian context, it is yet to be implemented in that great detail. But given that more and more companies are going into insolvency, and especially the EPC companies and the other infra companies which do not have the underlying asset base of its own, and which actually move to a liquidation situation, there I think this asset class assumes more significance, and that is where we will perhaps see some traction now. Referring to that, I think Anand has been a part of some of the efforts here in India. Anand has indeed been a resolution applicant in some of these cases, and as we speak, he's pursuing some of them. Anand, what's been your experience, and how do you see this as a market, and where do you see that it will be in, let us say, in a couple of years' time? You're on mute, I think, Anand.
There we go. Can you hear me? Good.
Yeah.
Yes, thank you, Anoop, and good evening to the rest of the panel as well. Well, I think this is a great subject to focus on, Anoop, for the simple reason that I refer to your preface, the way you opened this panel, that this is a separate asset class, and it has to be treated as such. It gets bunched into an insolvency regime because that is the origin of this carve-out, because they are a subset of the assets of the EPC companies. And in India, as everyone here knows, the EPC companies are the single largest portfolio of bad debt in some of the banks' books. Now, what I mean by a separate asset class is that a resolution, by its very nature, is forward-looking, right? It requires the repayment of a creditor obligation, which an RA agrees to, which has to come from making the underlying asset sweat. Whereas arbitration recoveries are necessarily a backward-looking exercise. You are resolving something that has always already happened, and there is no additional value that an RA or a buyer is going to add except the following, which is the least amount of capital insertion so as to price the risk appropriately, but very importantly, bring in a very different quality of legal input, perhaps, which the previous entity would not have been able to give. But also very importantly, and people perhaps sometimes gloss over this, as do sometimes the banks, that it is almost impossible to segregate and to treat arbitration as a mere legal strategy. Especially in EPC companies, the recovery of such claims is inextricably linked to the operations of these assets or of these claims and how they arose. So you cannot simply put a group of high-quality lawyers, put in some analysts to price the underlying asset, the underlying bid, and say, now let's play out a portfolio approach and hope that, out of 100, we will, have a hit ratio which justifies our investment. It is our view that intelligent recoveries requires putting in an operational team of high quality industry experts so as to be able to decide how far to push legally and how far and when to settle. And of course, the legal mechanism, as everywhere else in the world, is merely a way to enforce pressure on the counterparty, because enforcement, as we all know, is hard in the country. So you can even win the award and then, keep fighting out the enforcement regime. And, it is better to figure out what is the right way to get out of this as soon as possible. So there are 5 things that we, look at. I mean, if I were to list out 5 things, I would say, first of all, that this asset class is extremely tough to price, right? So as an investor, we find it almost always the prudent thing to do is to transfer the first loss to the counterparty, in this case, the banks. Because we can either price in a risk at pennies on the dollar, similar to what your previous panelist mentioned, which is, if he's offering or at least valuing broadly 10 cents to the dollar, I mean, at least that's somewhat of a benchmark for his firm. From the way we approach it, we would look at transferring the first loss to the seller and be willing to fund the entire litigation funding and bring in our core set of financial and operational ability and skill sets to resolve and capital to fund the litigation as long as it takes, judiciously so. Second, these assets have to be treated in a portfolio, because if you were to treat it, I mean, the value of these claims only gets created if you're looking at an entire set of them so that you can be forgiven for making mistakes in 1 or 2. Now, fortunately, the size of this pool of assets is so large in the country that we're finding it is not that hard to create and aggregate such claims. So I'll just do a little shameless plug-in for Payard as to what Payard is doing. So Payard is a specialist investor in infrastructure and construction companies in India. We have been the RA for 2. We're now in advanced stages of perhaps acquiring and closing on one of the large construction acquisitions. Now, in all of these acquisitions and resolutions, we have found a way to carve out the arbitration claims and bunch them into a separate vehicle. And we find that banks understand that it is tough to do a hard underwrite of these assets, and they're willing to work on a risk and reward basis. So we find that to be a good way to work with them. And I think the last thing, the 2 points that I had, which I think have been covered earlier in the panel, is that this is still an unwieldy legal framework in terms of right to sue, right to recover. And while there are, and indeed there are mechanisms to work around it, I think as we move forward over the next 12, 18, 24 months, this entire enforcement regime and the recovery regime will have to be understood and appreciated by the lenders as a distinct asset class, because there is too much money just waiting, just getting washed away and getting wasted in terms of both the time that is being spent and the litigations that just go on endlessly. So our view is that this will become a significant asset class in the coming 24 months on its own merits. But it will have to be accompanied by not only a legal strategy, but also an operational skill set, which is specialist to the domains in which it exists.
Thanks, Anoop. I think it's very important to understand, this market going forward, because as you said, that it's very difficult to price it, especially in the Indian context. And I think it'll be generally applicable to other jurisdictions also, that you also have a counterclaims at times, and you do not know at the time of taking this asset as to how the counterclaim will pan out. Now you can assume that in an insolvency situation, once the insolvency is resolved or the assets are liquidated, then the counterclaims will die down, as in they will get resolved. But it is yet to be seen as to how the arbitrator or how the court will view this. Will they apply the principles of set off, or they will consider the counterclaims to have completely resolved, and then they award the claim to the company. But one one good part is that, increasingly lenders are, taking it seriously. As I said that, in some cases where the assets are not existing at all and the debt levels are quite high, this remains as the only significant asset class from where, you can do the recovery. So that is, come as a, I would say that, area where lenders are now not willingly, knowingly, but because of the necessity, now they are getting interested in it. But what is more important is for lenders to understand that, the recoveries do not happen by way of a upfront payment in these kind of asset class, and they need to, appreciate that, there has to be a sharing mechanism in this. Uh, I believe that, it will take some more time for lenders to understand and accept that reality. But as you said rightly, Anand, that, it's a huge area, and the money to be recovered is massive, and therefore, I'm hopeful that, this will definitely develop into a matured market, both for the investors and for lenders and other professionals. Now, Piyush, coming back to you on your experience with Singapore. Uh, how have they dealt with, some of these issues that Arvindran and Anand have, discussed here, and what has been the regulatory development in Singapore on some of these issues?
Sure. The latest, I spoke about third-party funding in arbitration, and also now, which in an insolvency scenario has been recognized. The latest development to all this is something that the government has done, and it's called the Insolvency Restructuring and Dissolution Act of 2018, which came into force last year. That provides, again, the legal impetus to all this, that expressly authorizing the liquidator to do certain actions. They were, as we discussed earlier, the cause of action could be assigned. So that was something that was clear in the Singapore scenario. But what has happened now with this new enactment, which is something similar to the IBC, which also seeks to consolidate the insolvency and bankruptcy regime in Singapore, is that it expressly authorizes the liquidators to go after claims which are like what we call the clawback claims. So that's something that has been done. Like for example, transactions which are at an undervalue, etc. So they can now, under the regime in Singapore, are expressly authorized to look after third-party funding and go after such claims as well. So that only expands the regulatory framework. And I think that is something which obviously is helpful, that if you have clarity, because from what I'm hearing both from Arvind and Anoop, is that in the absence of such clarity, it only hampers the recognition of such these claims as an asset class. So to that extent, Singapore has been proactive in clarifying that regime, and has only not just the case laws, but also the regulation, the acts here have also gone ahead and provided more clarity. Now, I mentioned earlier about the recent amendment to the Civil Law Act, where the government has expanded the third-party funding regime to also include domestic arbitration. And there, they did explicitly mention that the experience, and Arvind again is a better person to speak about it, but the experience, in the last 4 years since the expansion of the third-party funding or explicit recognition has been good in Singapore. So there has been an uptake, and I've seen a number of arbitrations, especially where third-party funders have been involved. So it looks like because of the clarity in the regulatory regime, there has been an uptick, and looks like with more support and clarity, in the future, especially now with COVID-19 hitting the construction sector badly, there would be more parties looking at this third-party funding regime, and this could help in resolving those disputes.
Yeah, thanks, Piyush. Arvind, I mean, what Anand said that, when you talk about recovery under the arbitration claims, then, you can't see it on a standalone basis. You also need to see it from a perspective of, how good and how strong is your operational team, along with the experts who will deal with the claims. So, from your perspective as an investor, do you think you would always have to sort of tie up with the someone who also brings in the operational expertise, or you think that this can be pursued as an independent asset class and an investment
Thanks for that. Again, thanks for that. I if I understood Anand's comment correctly, and that's a very interesting perspective that his organization brings, which is to marry the legal expertise that you would have with a team of lawyers together with individuals who have specific expertise, perhaps with that industry in which that company is involved in. So you have this dual-pronged approach. Because our core business at Omni Bridgeway is in really dealing with the disputes side of things. We don't form a view on the operational aspects of the company. And in a liquidation scenario, that really takes a backseat, doesn't it? So in a liquidation scenario, we work with the resolution professional and the legal team in order to make an assessment as to the merits of the claim. So unlike, say, a private equity fund, we don't take a board seat, for example, on the company and try and turn the company around by involving ourselves in the day-to-day operational issues, because that's not our core business. Our expertise really lies in assessing the claims, and then one step after that, which is the enforcement of awards. Now, can I just make a couple of quick observations? There's been this discussion about claims and arbitrations and so on, and I think that we need to draw a distinction between claims at the outset, where you start funding a potential claim. So a company may have a suit against counterparty, right? So that's one type of, one subset of the asset class, if you'd like to call it. And then you have the second subset, which is perhaps the more interesting subset, which are awards that the company has already obtained after having gone through the arbitration process. So from an investor's perspective, whether you look at it on a standalone basis or on a portfolio basis, what is attractive is if the investee company has an award or several awards that can constitute a portfolio. Because now when you come in as a funder, your risk is mitigated because you're not funding from day one. You are funding just the enforcement leg of it. And when you're talking about the enforcement leg in India, and of course, it's a very large country and different states, different state courts have differing levels of sophistication. But if you're talking about Delhi and Mumbai, you can roughly anticipate when that award will reach a status where it will no longer be assailed, where it will be pretty ironclad. And that, in our experience, may take anywhere between 3 years to about 5 years, 6 years, right? It depends. Because it turns on the quality of the award. I think Anand's point stands. You really need to be quite careful about that. You really need to scrutinize the quality of the award, and you need to see, well, is this something that if it was brought before an Indian judge, as it would invariably be in EPC disputes because your counterparties are government entities, will the Indian judge in question exercise his more interventionist tendencies and then engage in judicial overreach, which is not supposed to happen under the scheme of the Indian Arbitration Act? And we've seen that happen. And then the roller coaster ride of it going on appeal and then subsequently to the Supreme Court. So from an investor's perspective, it's a timing issue. So perhaps I can share with you, generally speaking, when we look at an opportunity, we look at an exit within about 3 years from the time we start funding. In the Indian context, we need to think about it as a slightly longer term play. So that's one point I wanted to just put across to the audience, right? Don't think of it just as claims that are inchoate, that haven't really kicked off. You also need to think about the awards that you have. Now, naturally, I'll just wrap the point up very quickly before I move on to my second point. When we are approached by Indian promoters, it's very often that they say they've got these very high value awards, 100 million, 200 million, 300 million, sometimes even larger. And I'm talking US dollar terms here. And then there is also the pre-judgment interest component, which in the Indian context is very large. So that adds whatever it does to the award value. Just something to be conscious of is that when it comes to, for example, trying to reach a settlement or compromise, that will be discounted invariably. So when we look at the opportunity, and one message that I perhaps can impart to members of the audience who might be Indian promoters is that when we talk about pricing, you look at it, a discount needs to be applied. So you can come with a $1 billion award, which we've seen before, but the true value is actually maybe 50-60% of that, right? So that's on point number one. Point number two is sort of directed at members of the audience who are from the lender side. I think it's a really innovative way for lenders to start thinking about partnering with organizations like ANATS and like Omni Bridgeway. Because in the ordinary case, what has happened here already is that the lenders are down, right? You've extended your financing, company is down. How do you recover? And the lenders are not prepared to throw good money after that into an asset class that, frankly speaking, they may not have the expertise to understand. And that's where specialists can come in and say, okay, you relax, stay back, we'll look at it, we'll put in the money. And naturally, in the waterfall mechanism, because our capital is at risk, and because it's on a non-recourse basis, we don't take security over the assets of the company and so on and so forth. The only security or collateral is against the recovery of these awards. And then we get our cut first, and then it's for the benefit of the creditors. Because if you talk about liquidation scenario, it's very clear, right? But if you talk about pre-liquidation scenarios where a company is in a stressed or distressed situation, you don't want to tip the company over into liquidation because that erodes the value of the company. And it's really not in the lender's long-term interest, the creditor's long-term interests. So I would encourage members who are in the audience who are part of lenders to think about, okay, how do we now use this financing solution that is, whether it's nascent or not in the Indian market, we're very excited about it, but to allow the borrowers to pursue these claims ultimately for the benefit of the lenders, because the recovery will come back to them at some point. So, but perhaps I'll stop there.
Thanks, Arvind. And I can tell you that there's a huge scope for both you and Anat going forward. Only thing I think. Both the resolution situation and the liquidation scenario are two different platforms. You will always have a set of claims which are intrinsically linked to the performance of the underlying project also. And in whereas in liquidation you will have a crystallized claims where it is not linked to the operation side. And that is where the nature of asset class, both in resolution and in liquidation, will be different. I've been receiving the calls from the organizers, so I think we need to wrap it up quickly. Anat, any thoughts that you want to share it to close this session?
I think just in summary, I think what Arvind mentioned is a very important distinction, which we perhaps did not make earlier, the difference between claims and awards. And awards are crystallized receipts, and which can be priced very differently from a claim, which is an ongoing adventure on the part of the underlying company, number one. And number two, I think maybe what is required is for the lenders, until such time that the enabling framework gets created, which treats arbitration financing and recoveries as potentially a sub-asset class within the insolvency regime, lenders have to take a more benign view on the input of parties, of investors, and not always make an adversarial and a pricing conversation as to, we've seen deals fall apart with lenders, on the difference of, maybe 2 cents or 1 cent, especially when there is no ability that they have or we have to price it differently. I mean, we'll be saying, fine, this is the number that we're willing to put out, and then we will see whatever comes out, we will share. And they're like, well, no, we want a little higher. And, you keep chasing the next dollar and you never close a deal. Whereas the outcome is, the recovery is a third party's obligation to pay, and the only point I was making, and what Arvind did mention is actually is true, and I agree that the arsenal that an investor has arises from a legal pursuit. And that is the underlying ability of the investor, and that is what he is building his business on. The operational skill set is only to know when to really settle and when to meet with the counterparty. So, for example, we've seen so many of these claims with NHAI that we've found could be settled more gently by having realistic conversations with the government rather than continuing to follow a pursuit in the courts. And because there's no certainty of the time limit that you have, once you enter into the judiciary, we found it to be more prudent to just get in and out, and you treat it like a portfolio. And if you're out in 3 to 5 years, then this is a terrific asset class. We've built about, we ourselves, out of a small operation like ours, have built a 10,000 crore, face value of claims. Now, that is still a drop with respect to what is available out there in the country. So we expect this to become a massive asset class over the coming few years. Thank you, Arvind. Thank you.
Thank you, Anand. Just the closing remark that even the counterparties and the important counterparties like NTPC, NHAI, I think now they are also increasingly feeling the need of assessing the claims and the awards, and whether or not they should challenge it, because challenging itself requires a lot of cost to be incurred by them, and they are therefore creating different committees within their organization. They will independently analyze that whether it is worth challenging or not, and if it is not, then to quickly settle. I think that will again sort of give a fillip to this asset class. With that, over to the organizers.